Hello friends, good afternoon and welcome to the EduSite Network. Our topic of discussion today is part of our ongoing series on intellectual property rights, and the specific topic for today is patentability requirements in India with special focus on non-obviousness. And friends, to take this topic further and to elaborate more upon it, we have with us our subject expert Mr. Ashwini Siwal, Assistant Professor in Intellectual Property Rights, Faculty of Law, University of Delhi. And with this very brief introduction, I welcome Sir to the studio. Sir, thank you so much for being here.
Thank you, Urvashi. Good morning, viewers. Well, as Urvashi rightly mentioned that we are running a series of lectures on intellectual property law. Friends, if you remember, we have discussed in my previous discourse one of the very crucial and important requirement for obtaining the patent. That is requirement for novelty or requirement of novelty. Today I am going to discuss another requirement, that is the third requirement as far as the substantive qualifications for obtaining the patent is concerned. That is the requirement in the form of non-obviousness. Friends, I would throw a light on this area, but would like to take you to one important point first of all, because it's time to recapitulate certain points first of all, and then we'll jump to our today's discussion and today's agenda, that is non-obviousness. We know that, and I presume that everyone understands it, there are four things to be seen when one seeks a patent protection on his or her work. The first thing is that the work over which the person seeking the protection has not been expressly excluded by purview of section 3 and 4 or by purview of section 3 and 4. The moment you are done and satisfied with this qualification that your work does not fall under section 3 and 4, it is outside the ambit of section 3 and 4. You have to see the further requirements, you will have to fulfill the further requirements. The next requirement that comes into row is the requirement in the form of novelty. Novelty we discussed yesterday in a very elaborate manner, in a very exhaustive fashion. The third requirement that comes into row is the requirement of non-obviousness, and the fourth one, the last one, is the utility. Friends, our today's deliverables would be to understand the concept of non-obviousness first of all. The next thing that we are going to do, to discuss and threadbarely analyze the elements of non-obviousness. And the third thing, some case laws we are going to take on non-obviousness, because in the subject of law, one cannot able to discern the things properly if he or she does not refer to the important case laws, where very crucial law points are propounded by the courts. Friends, as I just mentioned verbally, that there are four requirements to be seen or qualifications to be seen for obtaining the patent. Let us have a look at this slide where all these four requirements are comprised in a very nutshell manner. The first requirement, that the invention must not have been excluded by the Patent Act as non-patentable by purview of section 3 and 4, which we had discussed in a very exhaustive fashion. The next is that the work must be in respect of a new product and process. If you remember section 2(1)(l), that reads that a patent can be granted to a new product or a process, and section 2(j)(a) as well as section 2(l) provides us the definition for the word new invention and inventive step. The third category, the third requirement is the requirement in the form of inventive step to be there or must be there, so that it ensures the non-obviousness involved in that. And the fourth is the industrial applicability or the capability of industrial application of the work of the product or a process. As I discussed previously also, friends, that these four requirements, or especially the three requirements in the form of novelty, non-obviousness and utility, these three requirements in India and in UK are called or are termed as new, inventive step, and third in the form of capable of industrial application. Friends, but the similar requirements, the identical requirements, are termed differently in the United States. They are called novelty, they are called non-obviousness, and they are called utility. As I mentioned earlier, that there does not lie any distinction as far as their definitions are concerned, the concepts are concerned, or say tests to gauge assess these requirements are concerned, they are similar. There lies only the terminological difference in India and in US. So for the purpose of our convenience, we can use these terms interchangeably. We can use a term new instead of novelty. We can use a term inventive step instead of non-obviousness. We can use a term utility instead of capable of industrial application, or vice versa is also true. Friends, some of the important points I would like to highlight first of all, as I mentioned in my previous discourse, that these three requirements in the form of novelty, non-obviousness and utility are separate requirements, but they are related requirements of patentability. They are separate, have to be fulfilled separately, but they are related as their definitions are provided in the definitional clause under section 2.1L, 2.1JA and 2.1M primarily. These three sections talks about these three requirements, or we can say these three sections are covering these three requirements in their stead and sweep. The next important point to be understood by all the viewers, only after our assumption that the following requirements are getting fulfilled, or say for finally seeing these requirements or these qualifications, we will have to assume that they are not prohibited by section 3 and 4. They have qualified the test laid down by section 3 and 4. They do not fall under the non-patentable inventions under section 3 and 4. Only then we will look forward to, or we will proceed ahead to see the requirements in the form of novelty, non-obviousness and utility. Without that, there is no need to see, because your work may get hit by the section 3, may get hit by section 4, which consists works which are not patentable. So there is no point of risking, or there is no point of trying to prove the further requirements of novelty, non-obviousness and utility if your subject matter is excluded explicitly by section 3 and 4. So it's better to satisfy yourself first of all that your work does not fall under section 3 and 4, only then you will have to jump to the requirement of novelty as discussed by me in my previous discourse, and to the new requirement which I am going to discuss with you today, its requirement in the form of non-obviousness. Well, let's get started with the requirement of non-obviousness, friends. Understanding concept of non-obviousness and its elements and some case laws on non-obviousness would be our today's deliverables, would be our agenda for today's discussion. I would jump directly without wasting any time to the concept of non-obviousness. The question must arise into the mind of the reader, into the mind of the viewer, as to what does non-obviousness mean and how is it different from novelty, the preceding requirement for fetching the patent. Friends, they are different. There lies a distinction, a conceptual distinction first of all, and in practical terms also there lies a difference between these two separate requirements or qualifications for obtaining the patent. We will understand that distinction, and I would make it very simplistic and simple for my all viewers to understand it and comprehend it in a very quick fashion. Concept of non-obviousness comprises the following things to be understood by all the viewers, all the readers, that in addition to other requirements in the form of novelty, in the form of utility, there lies one requirement which is called as the most important, most stringent requirement, that is non-obviousness, or the invention must be non-obvious too for getting the patent. If it is not non-obvious, if it lacks the qualification in the form of non-obvious, it cannot be given a patent. Another thing to understand the concept of non-obviousness, this requirement of non-obviousness lies under section 2.1JA of the Patents Act 1970. Friends, section 2.1JA is a very good and a very beautifully worded provision comprising some of the elements to be proved and to be established for proving the non-obviousness. We will take out those elements one by one when we will read the language of section 2(1)(ja). First you need to understand that this requirement has been posited or posed by this Patents Act 1970 under section 2(1)(ja). And one more thing I would like to put across here at this juncture, that this section 2(1)(ja) does not define directly non-obviousness. It provides us the understanding and explanation for understanding what would be called inventive step, what would constitute inventive step for an invention. Because friends, if you remember section 2(1)(m) of the Patents Act 1970, which reads that patent has to be granted to the new product or a process involving an inventive step and capable of industrial application. So there has to be a inventive step involved in a new product or a process for fetching the patent protection, for rising to the merit of getting the patent. So this inventive step is defined under section 2(1)(ja), which we will deal in our today's discourse. Another important aspect, that it is most significant obstacle that the patent application faces in the form of non-obviousness. As I mentioned, that this requirement or this qualification of non-obviousness is one of the trickiest and most stringent requirement, as mentioned in the slide in the third point, that it is the most significant obstacle that the patent application faces while seeking the patent protection. Novelty is one thing, non-obviousness is another qualification. One applicant seeking a patent may prove or may be able to prove the novelty, but it may get hit by the qualification of non-obviousness, or his work may get hit or negated by the qualification of non-obviousness. So he has to prove the qualification of non-obviousness as well, along with the qualification of novelty, which we have discussed in our previous discourse. So friends, as I mentioned, that it is a most significant obstacle or a hurdle for a patent applicant while applying for the patent protection or seeking the patent protection. Let's see another important point which would make the conceptual basis of the non-obviousness. It says that this requirement of non-obviousness is termed as the final gatekeeper of the patent system. It is termed as the final gatekeeper. There are another requirements also to be fulfilled by the seeker, I mean the person applying for the patent protection, but this requirement, as mentioned and highlighted under this slide in the fourth point, that it is the final gatekeeper of the patent system. So it demonstrates that this requirement is the stringent and the tedious one, is the most trickiest requirement or a qualification to be fulfilled by the patent seeker. If we will fail that in proving it, in that case he would be denied the patent or the grant of the patent. He cannot be granted a patent right in that case. So it is a significant hurdle. First of all, it is a final gatekeeper in the patent application for the patent applicant. As I highlighted, that all the requirements are to be fulfilled by the seeker of the patent, but one person seeking a patent may be able to prove the novelty, but his work may get hit by the qualification of non-obviousness or may get failed on terms of or on the assessment or appraisal of non-obviousness. Friends, some more points to understand the concept of non-obviousness. See, this requirement casts a broader net and check vis-a-vis requirement of novelty. When I say so, I mean that this requirement in the form of non-obviousness is much more harder and stringent to be proved and established in comparison with the requirement of novelty. As you all know, that in the case of the novelty requirement, one can prove it by proving his work novel or by claiming his work novel, and the PTO, Patent Trademark Office, or in our context, in Indian context, we can call a Controller General of Patents, may see it in a reference to a single prior art reference, and he will satisfy himself on the basis of that single prior art reference that the work claimed by the person seeking an invention is a novel work. But this requirement which we are going to study today in the form of a non-obviousness is much harder to be proved, is much stringent to be proved, because it casts broader check or a broader limit as far as the invention or a work of the person is concerned for seeking the patent or for obtaining the patent is concerned. As I mentioned and highlighted that in the case of the novelty only one single art has to be referred, but in the case of non-obviousness multiple prior arts are to be referred, and on the basis of or on the reference or on the gauging of multiple prior arts one has to determine whether the work is non-obvious or not. That I will make you understand later on when I will take up matter in a very full-fledged manner, but as I am discussing the conceptual basis or concepts relating to non-obviousness first, and I will elaborate them later in our today's discourse itself. The next thing, that it recognizes that the limitations of the claimed invention may be scattered throughout more than one prior art reference. So friends, this second point shown in this slide is a corollary of the first point, What does it say? It says that this requirement of non-obviousness recognizes the limitation of the claimed invention which may be found scattered throughout more than one prior art reference. As elaborated by me in the very beginning of this slide, that in the case of the novelty only one prior art is to be referred, or on the basis of only one prior art the appraisal has to be done, but in the case of non-obviousness or for the test of non-obviousness multiple prior arts can be referred scattered or to be found scattered anywhere in any manner. That is how this requirement posits a stringent test to be fulfilled by the person seeking the patent protection. Further, this non-obviousness concept nevertheless that this requirement is one of the requirement to be fulfilled by the person seeking the patent. The person proves the novelty, nevertheless he has to meet the statutory requirement of proving the non-obviousness. He has the statutory requirement of proving the non-obviousness. As it reads, that if an invention is novel, it may nevertheless not meet the statutory requirements if it is not significantly different from the prior art. So there has to be a significant difference in your work vis-a-vis to the prior arts available. As I said, prior arts available, multiple prior arts available. In the case of a novelty, the test is to see the work in light of one prior art if available. If that one prior art identically available provides similar things which the inventor has come up and seeking a patent for, then in that case his work will not be called novel. But if by referring to a single prior art his work qualifies to be called a novel, he may be granted a patent. But in the case of non-obviousness, it may be a scenario where your work qualifies the requirement of novelty, but it fails on the test of non-obviousness, because the non-obviousness test requires a significant difference on the appraisal and gauging your work with the multiple prior arts. I will elaborate it further. Let us see and jump to another section while understanding and discussing the concept of non-obviousness. It's about the history of the origin of non-obviousness requirement. History of the origin of non-obvious requirement. Friends, in this case law, it's a United States case law, it's Hotchkiss versus Greenwood. It was a case, famous case for a doorknob in the year 1851, in this case, as mentioned in the slide, the court has highlighted a very important point which reads that this case is widely regarded as creating an additional patentability hurdle above and beyond novelty and utility. So this was the first case where we got the requirement of non-obviousness discussed by the court in the year 1851, where they brought a new requirement or a new hurdle for obtaining the patent above and beyond novelty and utility, which required an inventor to display more ingenuity and skill than that possessed by ordinary mechanic. Friends, if you focus on the last part, on the later part of this sentence, this paragraph, it reads that this requirement must demonstrate some more genuinity and skill than that possessed by the ordinary mechanic. These are the words used by the judges in the doorknob case in the year 1851, and this case for the first time heralded a new patentability hurdle in the form of non-obviousness. What does it say? It reads that the work over which you are seeking a patent for, it has to prove some ingenuity and skill, more ingenuity and more skill than that possessed by the ordinary mechanic in that particular discipline. For example, a person comes up with work A, and there lies some other works called B, C and D. In this case, in this instance, if the person seeking the patent on the work A wants to prove that there lies a non-obviousness in his work, he has to first of all prove that there is a significant difference in his work vis-a-vis to other works in the form of B, C and D. And how he will gonna prove it? He will have to prove it by showing some more ingenuity and skill applied by him than that possessed by an ordinary mechanic in that particular discipline. What does it mean? In practical terms, it means that a person or a mechanic who is having an ordinary knowledge about the work B, C and D, if that mechanic having a ordinary knowledge or say skill in the work B, C and D, if he can thought of coming with the same work which the inventor has come up in this instance, say work A, then in that case the work created by the inventor, a work in the form of A, will not be given a patent because it would get hit by the requirement of non-obviousness. It would be called obvious to the person who is an ordinary mechanic. It would be called a work obvious to a person who is ordinarily skilled in that art, who is a person of skill in that art. So it cannot be given a patent protection because it is getting hit or negated by the requirement of non-obviousness, notwithstanding that it is novel or it has proved the test of novelty, has cleared the test, the preceding test of novelty. Friends, if we say or talk about little more about the history of the origin of non-obviousness requirement, we will see one more celebrated case, that is your case law called Graham versus John Deere. I am going to discuss that, but before that let us see that there was a rule prevailing in the United States until 1952, and that was a rule of that if the work is the flash of the genius or some sudden insight, then in that case his work is a non-obvious work, something which is not obvious to the ordinary mechanic or ordinary person. As I mentioned that this kind of a concept was first heralded in the case of Hotchkiss in the year 1851, and they have developed a seminal jurisprudence later on in many years. In the year 1952 or till the year 1952, the concept of flash of the genius, the concept of some sudden insight created by the person remained prevalent or pervasive, and things used to be governed by that concept itself, that concept only. The view was that the invention must have been so non-obvious that no amount of diligent research would have produced it. Friends, if you take note of this sentence or this point, which reads that the view until 1952 was that the invention must have been so non-obvious that no amount of diligent research would have produced it. But now the present act says that whether an invention is produced by the dint of arduous research or a flash of genius does not determine whether it is non-obvious. So there is a shift as far as this concept is concerned, or the test to determine the non-obviousness is concerned. Until 1952 in the United States, it was flash of the genius or some sudden insight of the person. But now the present act in the United States says that whether an invention produced by the dint of arduous research or a flash of genius, merely this does not determine whether it is non-obvious. Some more things have to be seen. The present method of determining non-obviousness is by reference to the prior art. This method, which is written in the last point in this slide, has never been the method of appraising the appraising the qualification of non-obviousness, has never been the test to determine the non-obviousness. But as I told that after 1851, when we got the concept of non-obviousness as a one more hurdle for obtaining the patent in the Hotchkiss case, until 1952, the concept, the rule which governed it was flash of the genius or sudden insight. But now the present act says that these two things are not suffice to determine whether it is non-obvious. There has to be something more to determine whether the work is really non-obvious or not. If the work is non-obvious, in that case it can be granted a patent. If the work is obvious, then it cannot be granted a patent. It has to be non-obvious. It has to fulfill the qualification of non-obviousness. It must involve the requirements to be called non-obvious. As I mentioned in the last point here, that the work to be called a non-obvious has to have something extra, some additional thing, and as per the present statutes in all over countries, in all over the world, in almost many countries, especially in India, as we are talking about the Indian context and the requirement for obtaining the patent in India, we have a requirement of non-obviousness to be proved by referring to the multiple prior arts. So it is not mere a flash of a genius, it is no more a sudden insight of a person which would be termed a work which would be termed a non-obvious work for fetching the patent protection. It has to be, first of all, deny or negate the multiple prior art references. It must not be the same thing or copy of the multiple prior arts. If it is a copy or a same thing of the multiple prior arts, in that case it cannot be given a patent. But if it is not, then in that case it may be given a patent protection subject to other qualifications of utility and novelty. Friends, if we see some more things about the historical origin of the concept of non-obviousness, we get to see this very important case, Graham versus John Deere of 1966 of the United States Supreme Court. This case law provides Graham factors for determining non-obviousness, and these factors are still valuable, are still prevalent, are still important whenever there comes a question of gauging the non-obviousness, whenever there comes a question of assessing the requirement of non-obviousness for the patentability. This case law laid down the following factors to be considered in determining whether an invention is non-obvious and deserving for patent. Let us see what are those factors. The first factor which this particular case law propounded is the pertinent prior art. I would explain this factor right here for my all viewers to understand it. See, when this case law was going on and when it was decided, the court came up with concrete factors to be considered in determining whether an invention is patentable or not, on the grounds of non-obviousness, on the test of non-obviousness. The first factor which reads pertinent prior art. When we discuss and elaborate this factor primarily is based on the premise that the work over which a person is seeking a patent has to deny that his work is not verbatimly based on pertinent prior arts, has to be negated on the ground of, on the qualification of pertinent prior arts. If it gets negated, only then it can be given a patent protection, only then it would be termed as non-obvious. So, if there is one art or if there are many prior arts which are called pertinent here means or demonstrates pertinent for that particular discipline, particular for that particular invention, in regard to that invention, concerning that invention, concerning that discipline. So, by referring to those prior arts available, say A, B, C, D are the prior arts available in the form of publications, in the form of postings on internet, in the form of word of mouth, in the form of, many methods can be there to explain you. But the point is, if the prior arts are there which are pertinent to the work in question or the subject matter in question over which a person is seeking a patent claim, if on those pertinent prior arts your work over which you are seeking a patent qualifies or your work negates those works, your work cannot be called copy of those works, cannot be called verbatim thing of those works, cannot be called a work which is a work which a normal or a ordinary person skilled in that art can do. In that case, you can be given a patent protection. So, pertinent prior arts are to be referred for determining whether the person deserves a patent, whether the person's invention is non-obvious. Those pertinent prior arts are to be taken together at one point of a time, and the attempt of the controller of the patent while examining this factor would be to gather as many prior arts as possible pertaining to that particular invention, and on those pertinent prior arts it has to be gauged, it has to be assessed and analyzed. If it would be found that it is a kind of a work which a normal or a ordinary person or a ordinary mechanic of that field can do or would have done, then in that case it would fail the test of non-obviousness. It would be called a obvious work to the ordinary mechanic, obvious to a person who is skilled in that art, who can refer to those multiple prior arts and come up with the same work, or can create the same work, or would have created the same work had he been given that task, had he been aware about those multiple prior arts. That is how the first factor, which I call a very crucial factor, let down or propounded by the Supreme Court United States in Graham versus John Deere in the year 1966. The next factor is difference between the prior art and the invention. This is also a very crucial factor, friends, that there should be a difference between the prior art and the invention. I would elaborate or would like to discuss it. This particular factor provides a requirement that there has to be a significant difference between the prior art and your invention. If your invention does not possess significant difference vis-a-vis to the prior art or prior arts available, in that case it would fail on the test of non-obviousness and will not be granted a patent. And in that case it will not be granted a patent protection. Friends, this factor in the form of there has to be a difference between the prior art and the invention is a very crucial factor to be taken into consideration by a person analyzing the test of non-obviousness or by a person analyzing the claim made by the person on the test of non-obviousness. I would like to take you on the another factor which to my understanding is again a very important factor that speaks that the level of ordinary skill in the prior art. This factor requires that whenever the person seeking a patent protection over his work, he has to show the significant difference in his work or in his invention vis-a-vis to the prior art by referring to the level of ordinary skill in the prior art. He has to refer to the level of ordinary skill in the prior art. If it does not refer to the ordinary skill in the prior art, what does it mean? It means that the person seeking the patent has to prove that if the ordinary person skilled in that art would have created this work had he been given this task or had he been thought of creating this work, if he would have simply created it, then there does not lie any non-obviousness in it. Then it means it is simply obvious. Obvious to whom? Obvious to the person skilled in that art. One who is well versed or one who is knowing about it. I would like to pause here for a moment to explain you that whenever we talk about a person having ordinary skill in the art, we never imagine or assume a person having a sophisticated knowledge. We never assume a person possessing genius mind. We never assume a person who is a lay person or an idiot. We assume a reasonable person, a prudent person, one who can or could have created the similar work by referring to the multiple prior arts, and he would have also brought the same significant difference in his work if he would have created it, or had he been assigned that work to create it, or had he thought to create that work. So that is how this obviousness has to be seen by applying these Graham factors, which are very important, and in many cases even today these Graham factors are applied to check the non-obviousness involved in the matter. The first one is there has to be pertinent prior arts or their appraisal. Prior arts or pertinent prior arts are to be appraised, are to be assessed. The next is some significant difference between the prior art and the invention has to be proved. Now, I would like to tell you one more thing here, that when we talk about the significant difference, we may say that there has to be some significant increment. It should not be a workshop increment. It has to be a significant increment or an improvement in the work. If it is mere workshop improvement which any ordinary mechanic can do or can make, in that case it would not be termed as a non-obvious work, it would be termed as a obvious work. Obvious to whom? Obvious to a person ordinarily skilled in that art. And that is the real test. Whenever you gonna see to assess the obviousness involved in the work, you will have to see that obviousness in context of a person who is an ordinary mechanic in that art, who is having an ordinary skill in that art. And who would be the person called possessing the ordinary skill? The person who possesses the reasonable prudence. He should not be having or possessing the sophisticated knowledge. He should not be a genius. He should not be a lay person. There has to be a balance while determining the person skilled in the ordinary art. That is why I call that he should be a prudent, reasonably prudent person to think about the things and to create the things in this manner. Well, the next requirement as highlighted and described by me, that level of ordinary skill in the art, that is prior art, has to be seen, where we see that the person who is ordinarily skilled in that art, his level, his understanding, his skills are to be seen, reasonable person's skills are to be seen, reasonably prudent person's skills are to be seen to determine whether he can be able to make the same thing with the prior arts available. If yes, then in that case it is not obvious, it is getting negated by the test of non-obviousness, and no patent can be granted because it lacks the non-obviousness. It may qualify on the ground of novelty, but non-obviousness will strike it down. As I mentioned, that non-obviousness is a very crucial and a stringent requirement vis-a-vis to novelty, because in the case of the novelty only one single art has to be referred, but in the case of the non-obviousness multiple prior arts are to be referred, and that too in light of the person skilled ordinarily in that art, or in the background of the person skilled ordinarily in that art. If he thinks that he can create it, if he thinks that he could have created it, if he would have just, if had added those multiple prior arts, compiled those prior arts, then that lacks the non-obviousness. That lacks the requirement of non-obviousness and does not qualify for obtaining the patent. Well, another thing that we must see, as far as this case called Graham versus John Deere, decided by the United States Supreme Court in the year 1966, it provides some secondary considerations also to be seen along with the primary considerations as highlighted in a yellow color here in this slide. These are the primary considerations, but there are some secondary considerations also to be seen or to be gauged. These are as follows. 1. Commercial success. When it says that if the invention is commercially successful, if somebody's invention is commercially successful, then in that case it may be termed as non-obvious. See, apart from applying the earlier tests or preceding tests, some of the factors which are called secondary factors or considerations, they can also be applied to determine whether the work is non-obvious or not. One is commercial success. So when I say commercial success, and when the judges in this case propounded the principle of commercial success, they meant that if the work of the inventor in the form of an invention is commercially very successful, that means his work is non-obvious. But there is a catch here, viewers, which we need to understand. This work which is commercially successful, this work may be called a commercially successful because of the reason that it has been marketed aggressively and properly, and the other works of the similar sort have not been aggressively marketed or properly marketed. So we will have to keep in mind that if the work is having a commercial success, then it must have that commercial success, it must possess that commercial success on the basis of some inherent trait or inherent qualification or inherent feature involved in that work. If it is because of the aggressive marketing, if it is because of some sort of other mechanism, if it is successful because of aggressive marketing, other successful means, in that case it would not be termed as non-obvious. It would be termed as non-obvious only when it possesses, it comprises some inherent trait or a feature involved in it which makes it non-obvious and which makes it commercially successful. Moreover, if we would like to understand it further, this test of commercial success, we can provide one more analogy, that whenever the work is commercially successful, and it is termed as non-obvious because others would also have made the similar work had there been a thought of making that kind of a work in their mind, and that would have been also commercially successful, but they failed, and one person who created it, invented it, produced it into the market and made it commercially successful, he'll be called a person owning a work which is non-obvious, but there has to be a requirement fulfilled by him that this non-obviousness involved in his work is because of the inherent feature of that particular work, not because of the aggressive marketing or some other kind of a tactics applied by him. Another secondary requirement posed by the Graham versus John Deere is the requirement of long felt need. Suppose a person comes up with a work whose need is long felt, people are requiring it, but nobody is creating it or has not been created by anybody. People are aspiring or looking forward for such kind of an invention or a technology to be used by them. One person, one Mr. A comes with it and he seeks a patent over it, and he claims that this is a long felt need of the society and I have created it at a very reasonable and affordable price. In that case, this secondary consideration or this test of long felt need would get satisfied and he may be given a patent protection, as his work would be called a non-obvious work. It would no more a obvious work, as it was a long felt need, and when the people were in the need of that work, why didn't they create it? When one inventor is creating it, he should be rewarded and incentivized with the patent protection, but that must qualify the requirement of non-obviousness, and long felt need work qualifies the requirement of non-obviousness. Another factor or another consideration, which is a secondary consideration to be seen, commercial acquisitions. If the work created by the person is being transferred by licenses, by assignments, is being taken by the people, or much sought after work by the people by paying heavy royalties and heavy fees to the inventor, then that work would also be called a non-obvious work. But that kind of a commercial success or a acquisitions must be because of the inherent trait or a feature of that work. It must not be because of the aggressive market or some marketing tactic applied by the person or the inventor. Another factor, copying. If the work of the person which he has invented is being copied at a mass level, is being infringed by many people, it means that the people are looking forward to his work, as he has created a work which is a non-obvious work. Apart from being novel, it is non-obvious too, because people are copying it and infringing his work. So with that kind of an infringement or copying done by others over his work would suggest the inference that his work is non-obvious. Otherwise people would have created it on their own and they would not have required to copy it, infringe it. So that is how the following tests given under the Graham versus John Deere in the year 1966 are to be applied by the people. Let's have a look again over these two kinds of considerations or factors propounded by this court, Supreme Court, United States in the year 1966. The secondary considerations are given as follows: commercial success, long felt need, commercial acquisitions and copying, and the primary considerations are given in the previous slide, which are as follows: the pertinent prior art, it should be providing some significant difference between the prior art and the invention, and the level of ordinary skill person has to be seen, has to be assessed with a view to the prior art available. Well, let us proceed ahead, friends, after completing this section of secondary considerations. there is one important and a pertinent point to be noticed, that the party claiming non-obviousness on these grounds must show some nexus between the secondary characteristics and the invention. That is something inherent in the invention to make it success, as mentioned by me while discussing these factors. Now, let us see the non-obviousness and inventive step in India. Friends, this requirement of inventive step to be present in the work of the person to discern this concept of non-obviousness in Indian context, we will have to read two provisions together as highlighted in the first point in the slide, 21J and 21JA. 21J reads that invention means a new product or a process involving an inventive step. As demarcated by me in a different color in this slide, inventive step is one of the requirement posed by section 21J, and this is further explained under section 21JA, which reads a feature of an invention involving a technical advance as compared to the existing knowledge or having economic significance or both, and that makes the invention not obvious to a person skilled in the art. Friends, I would like to draw your attention here, and I request all of you to kindly have attention to these demarcated things in this particular clause, that is 21JA. It reads that inventive step means a feature of an invention that involves technical advance. So, one thing that a person needs to prove when he seeks the patent over his work, that there has to be a technical advancement in his work, involved in his work vis-a-vis to the other works available. One thing that is to be seen and noticed by the viewers in the definition of the inventive step is that there has to be a technical advancement. I would explain it in a very elaborate manner as to what does this technical advancement mean in this context. And the next requirement as posed and posited in the same definition here is the requirement of economic significance. These two requirements posed by section 21JA, one is technical advancement in the work and the economic significance, or and can be used interchangeably here because these two requirements are alternative requirements to be proved by the person seeking the patent. He proves either one or both, it's up to him. If he proves both, it's well and good. Otherwise, if one has been satisfied, if some technical advancement has been showed and proved and established by the person in his work, in that case he would be given a patent protection, as his work will be called or has reached to the merit to be called a work which is non-obvious or a work which is not obvious to the person skilled ordinarily in that art. The next requirement is the requirement of economic significance, or he may prove both. Another thing that has to be noticed by the viewers in the last part of this slide under section 21J, in the later part of this language, that makes the invention not obvious to a person skilled in the art. Friends, as demarcated by me in the end of this 21JA, that the concerned invention must involve a technical advancement or a economic significance, and that is not obvious to a person skilled in the art. This last part, which has been highlighted and demarcated by me, that the person skilled in the art must not know it. It should not be obvious for him. Obvious for whom? Obvious for the person who is skilled in the art. So the final test to gauge the inventive step involved in the work requires that the economic significance or the technical advancement or both of these things, if proved by the person, they are to be proved by that person in context of the person skilled in that art. If a person who is dumbhead, if he does not know anything about that field, or if he is a lay person of that field, if he does not know that work, that particular work will not be called a non-obvious work, would be called an obvious work. Because our test or the touchstone of our test, the key of our test is to see the things in light of or concerning the person possessing the ordinary skill in that art. He must not be having the or possessing the sophisticated geniusness or something like that. He has to be a reasonably prudent person, possessing a reasonable knowledge about the things about that particular field or a discipline. And if he thinks that this is not obvious, it involves a technical advancement in it, it involves economic significance in it, or maybe one of the requirements it fulfills, it can be called a non-obvious work, can be given a patent protection. I'll discuss it with some of the case laws. Well friends, as section 21JA postulates three things here, which are to be called the tests for determining the non-obviousness. One thing, that technical advancement has to be there compared with the existing knowledge. Another is there has to be an economic significance, and the third is that this invention is not obvious to a person skilled in that art. If it is obvious to that person, then it would not be termed a non-obvious, it would be an obvious and cannot be given a patent protection. So 2-3 things that I would like to mention in the last as takeaway for all of you at home today, that there has to be a technical advancement in the work, there has to be economic significance involved in the work, and there has to be, or both can be present or either can be present, and such advancement and economic significance must not have been obvious to FOSITA. FOSITA here stands for person who is ordinarily skilled in that art, and that particular test should be gauged in light of multiple prior arts as discussed by me in my today's discourse. Well, I rest here friends. I will meet you next time with the further discussion in this lecture series. Thank you so very much. Thank you very much.
Thank you so much, sir. That was extremely informative and also would lead us to perhaps further queries and ideas which we would like to explore. So thanks again, sir, for being here today, and thank you so much, viewers. Have a wonderful day ahead.